Hey everyone, welcome back. While sorting through my nearly full 20 terabyte hard drive packed with court cases I haven't covered yet, I stumbled upon a few from Georgia worth sharing. Today, we're looking at 3 self-proclaimed sovereign citizens and 1 self-titled king who apparently can't summon any royal power to post a simple cash bond. So, in total, 4 sovereign citizens to dive into. Let's get started.
I have 2 more cases on my calendar. Courtroom 2, who do we have next?
We have position number 12, Mr. Sparks.
Oh, 3 more cases. Okay. This is Mr. Louis Sparks, accused of a violation of the law regarding squatters, 16-7-21.1. Case number is 25 CR 000147E. Offense date appears to be December 20th, 2024. Now, Ms. Franklin Brennan, did you get that phone number that was sent to everyone? Okay, thank you. Okay. Mr. Sparks, you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is going to be Mr. Michael McLean. Any priors?
Well, no squatting or history. 124. He got an open case, ag assault, crude to the third, criminal damage to property, 2nd degree, obstruction, simple assault. It's 24 PI 002815. Open theft by conversion, 22 SC 182232, 2018 FTA.
Ms. Allen?
Thank you, Your Honor. This is an incident from December the 20th. There was actually a hearing in magistrate court in front of
Judge Ashley.
Judge Ashley on the 7th. He found probable cause for a count of squatting. The owner of the location at 5558 Union Point Place in Union City had to do a private action for a warrant because the defendant refused to leave the premises. He's filed in a bunch of sovereign citizen, UCC, gobbledygook, and has an AKA. The victim in this case is Mr. Douglas Walls, the owner. Judge Ashley issued a $10,000 good bond after hearing on this matter. I would note that the open 24 PI case mentioned by pretrial is from April of 2024. The defendant in front of you was released on bond following his arrest in that case. And as part of that bond, he's been ordered to stay away from the location. That's the location where his wife and his 5 children live. And the case in Superior Court is an aggravated assault against her in front of those children.
So much for the claim that there's no living victim in this case. I have to say, it's hilarious how lawyers and judges have reached the point where the only way to capture sovereign citizen nonsense is by literally recording their gibberish in official transcripts. The absurdity with these people just never seems to end.
Fighting to stay at the property, even though he has no legal right or right to possess or be on the property, and the owner of that property had to go through the court system to get him out. The court has already ordered him to stay away from that location because of the open felony aggravated assault. We're asking to keep that $10,000 good bond that Judge Ashley put in place. I'm guessing it was for a reason. It might be part of the 60 pages of things that have been filed into this case and the gobbledygook and someone who just frankly refuses to acknowledge that they've been ordered to stay away. We will continue to try to be in contact with the victim in that 24 PI case, Your Honor, Mrs. Duncan, and I've already alerted the DA's office that this gentleman is now back in jail for a violation of the bond in that case. And so that's where we are. We'd ask for no contact with the gentleman who owns the location, Douglas Walls, or anyone else who's living there, to stay away from 5558 Union Point Place in Union City. No drugs, alcohol, or weapons. Thank you.
Mr. McLean?
Your Honor, my client, Mr. Sparks, is a high school graduate. He has been working in the ministry for a year and a moving company for 8 years prior to that. Based on the charges, he's also been in Georgia quite some time, over 11 years. He's 42. Your Honor, based on the charges, we understand what the state has been concerned about and is concerned about. We would ask the court to consider a signature bond, and if not a signature bond, then something like a $1,000 or $2,000 surety.
It's going to be a $5,000 surety bond. I'm not sure whether he's got a bond surrender in his 24 PI case 002815. I just see some notes about that, but y'all can look into it.
I didn't see that he had a bond surrender. It's just real clear he can't go back to that location as a condition of his bond. It's a $20,000 good bond, I believe.
Okay. But meanwhile, it is a $5,000 surety bond for this particular case to stay 500 yards away from 5558 Union Point Place in Union City, 30291, to have no further contact with Douglas Walls, no illegal drugs, no alcohol, and no weapons and no firearms. And his next court date will be January 20.
Apparently, even a self-proclaimed sovereign spouting legal gibberish can still get evicted. Quite a shock, considering the courts supposedly have no authority over the living man or woman, right? Now, onto our next case, featuring a so-called sovereign Karen who makes one of the most baffling legal blunders imaginable, one that ends up draining thousands of dollars from her pocket.
She's out of the breakout room, so we can go ahead and go forward on position number 1. All right, so Miss Ellis, you could come into the camera for me.
I'm here by special appearance, Judge. As a
hold on one second. So, Miss Ellis, if you, I just need to swear you in first, and then you can make your statement. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I stand in honor and affirm that my words shall be truthful with full reservation of my rights under God's laws and natural law.
Okay, you can put your hand down now. Thank you. All right. So I have already reviewed the case. I remember Miss Ellis from previous dispossessory where there was, a long story short, that the parties, at least at that time, did agree that she had taken subject to a valid lease. And that they had not asked, they had not pled for non-payment, and I'm assuming this is where this new dispossessory is based on the non-payment, based on the lease that she had with the previous owner. Is that correct, Mr. Thor?
That is correct, Your Honor.
Okay, and it looks like so, Ms. Ellis, I looked that you did file a late answer in this case. I saw that you had said you had emailed your answer or some sort of response to the plaintiff. That does not count as an official answer. So it actually, your answer does have to be uploaded into the file within the 7-day time frame. So it is a late answer. I did also just review that I didn't see any legal defenses or counterclaims in this. So this would technically today be a judgment on the pleadings. So Mr. Thorpe, if you'd like to present your case.
Yes, Your Honor. So this was filed for non-payment of rent. Service was effected on December 10th. No answer was filed. Defendant is in default. We request a immediate writ of possession.
Okay, with a judgment on the pleadings, it would be 7 days from today. So that would be the 5th of February. Since you, well,
Yeah.
technically,
That'll yeah.
It was a late answer. You are right.
May I, Judge?
Yeah, just 1 second. I'm just getting his case first, and then I'll come to you. Let's see. Yeah. Okay. So based on the answer being filed late, so you're just seeking the writ. You don't want the answer accepted, so you're just seeking the writ.
Correct, Your Honor.
Okay. Okay. So, Ms. Ellis, before you make your statement, I just want to make just a general statement about the fact about the answer being late. Okay. So here are the pros and cons. You filed a late answer. Like I said, there wasn't any legal defenses or counterclaims in the answer that you did file, but you did file a late answer. If you want me to accept that answer, that would subject you to being subject to a money judgment in the case. However, it would give you an additional 7 days before the plaintiff could file for a writ of possession. If your late answer, if you choose to have me not accept your late answer, then the writ would be available for them to apply for as early as today, but you would not be subject to any form of money judgment that they could use to collect on. But you would have to, the writ would be available to them a little bit 7 days earlier.
Someone who looks like she has 4K level senses, it's a shame she couldn't pick up on what the judge was clearly saying. Her choices were simple: admit she's wrong and possibly be ordered to move out that very day, or convince the judge to accept her nonsense filing as a late response, meaning she'd still have to move out within a week, but with a hefty money judgment added on. So, which option do you think our self-proclaimed legal expert chose?
So I guess my first question, so I guess if you'd like to make your statement, but then I'm going to need to know whether or not you want me to accept your late answer, because if you want me to accept your late answer, there would probably be a money judgment associated with your order, but the writ would be applied for in 7 days. If you do not want me to accept your late answer, it would just be a writ available today or whenever they filed for it already, I believe. The writ would be signed today, but there would not be a money judgment against you. Okay. All right. So if you'd like to make your statement now.
So under what authority is the abatement that I filed could not be the answer? Because is it ethical for the court not to accept the abatement that I filed, because that's how I usually filed, and it was always no problem?
Filed. There's nothing filed.
So I have that evidence because I went into the court and they showed me that was filed, and they said to me, that's what you were stating this court case on. So I want that answer to be put in place as the answer for that abatement.
If you file the late answer, like I said, it would subject you to a money judgment. I'm not sure what you mean in terms of an abatement, but the rules for dispossessories are pretty simple. If you have not paid your rent, they will file based on non-payment of rent. They'll issue a demand. And then if you do, and essentially, unless you can show that you've got some sort of legal defense,
I do.
The itself, and what would that be?
I do have legal defense. First, I want to repent for all my debts, and I like to rescind my prior actions to start over. I have evidence that I filed a case. I filed to buy the premises from the real party of interest. That's why I was asking this attorney if he does have evidence of who's the real party of interest on this property. Because even yesterday, I was speaking with the owner of the property, telling me that I need to send in a GAR and my proof of funds. So if this is not about possession or monetary value, because I have all that evidence.
So Ms. Ellis, in the previous case, it was shown that this plaintiff purchased the property at foreclosure. You had a lease with the former owner, and like I said, there's nothing along those lines. Hold on one second.
I do have that evidence, Judge, because we never get to that situation because of all the situations that were happening. I do have all that evidence. That's
do you want me to accept it? Ma'am, do you want me to accept your answer or no?
Yeah, I want you to accept my answer.
Doubt she's perfectly capable of getting oxygen to her head. It's just unfortunate there doesn't seem to be much up there making use of it.
On 7 days, but you can seek a money judgment. Ms. Ellis, you can make whatever argument. I've read through everything you filed in the case. It does not present any sort of legal defense to this dispossessory proceeding. All right, so Mr. Thorne, she does want her answer accepted. So if you'd like to present evidence on the rent owed, you can do that if you'd like.
I believe you have a copy of the lease agreement, Your Honor. Monthly rent is $23.50 with a $30 late fee. Rent has not been paid since October. It was found, I guess, in the prior case handled by the prior counsel that rent had been paid through September. So October, November, December, and January, and late fees would be $9,520.
Okay, you said it was $2,350 per month?
Correct.
And then that would be...
And a $30 late fee.
So you're not seeking... Okay, so you're just seeking through January?
Yes, Your Honor.
Okay. Let me just check.
And may I ask the question, Judge, if that's okay?
Just 1 second. Just 1 second.
Okay,
Yeah.
thank you.
1, 2, 3, 4.
Do I have that now?
Okay. So I did. So that's 4 months, October, November, December, and January at $23.50 per month, plus $120 and $30 late fees per month. That amount is $9,520. All right, Miss Ellis, what would you like to say?
So I just need to ask the question. So if the payment is not received while I'm negotiating with the owner to buy the property, you said in 7 days, what's the next step?
Well, they're not required to accept any if they choose to accept payment from you, that would cancel the writ in this case. So if you come to them and you guys are able to work something out and they agree to accept funds from you, that would cancel the writ of possession in this case. But again, that's something you'd have to reach out to Mr. Thorne to talk about. But again, like I said, if they did accept, the triggering thing is them accept. If they accept it, if they accept the funds, if you send in funds and they accept it, that would mean they would have to cancel the writ. But otherwise, the writ would be in place.
So what is being done today? You're filing a writ for possession in 7 days. Is that what you're doing?
Okay. The landlord will be able to, because I'm accepting your late answer per your request. The landlord is seeking a money judgment in the amount of $9,520. And then they will be able to apply for writ of possession by 11:59 p.m. on next Wednesday, which is the 5th of February.
So that will be a new case or the same case?
This is this case, ma'am. This is the order in this case.
So will I be back in court or not?
This case is going to be over as of today. This will be a final order in the case. I will enter that order, and then the writ will be available to them to apply for at 11:59 p.m. on the 5th of February.
So is this a default judgment that is going to be closing out today, you're saying?
This is not a default judgment. It's a judgment on the pleadings. You didn't present any legal defenses. I'm accepting your answer, but there are no legal defenses or counterclaims regarding this possessory. So they're going forward today just on the pleadings. Based on the pleadings, the amount owed is $9,520. And like I said, one more time, the writ will be available at 11:59 p.m. next Wednesday, which is February 5th.
Thank you.
All right. So that'll be the order of the court. Mr. Thorne, I will prepare that order. Okay?
Thank you, Your Honor. I appreciate it.
If she doesn't qualify as one of the dumbest sovereign citizens out there, she definitely earns the title of a true powerhouse of nonsense. Now, let's move on to our next case, featuring a man who claims to be a king, a monarch over his own land, and insists he has unrestricted access to every property, public or private, across the entire United States.
Harris is at the medical unit. He is accused of criminal trespass under case 24 CR 8301G. Mr. Harris, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney, and representing you is going to be either Mr. Bartell or Ms. Kim or Mr. Haddad. Okay.
No, Judge. So he's proceeding pro se.
Pro se? Okay. Thank you. Mr. Harris, you have a right to an attorney. If you choose to waive your right to counsel, then you will be depriving yourself of legal experience and expertise. If you decide to represent yourself, you are responsible for understanding the criminal laws and procedures and how they affect your personal freedom and your any other matters such as open cases, your job, your residency, or any other licenses you may have. And also what kind of impact it will have on your criminal conviction record if you have one. But it's really up to you whether you would like to have appointed counsel at no expense to you or whether you'd like to represent yourself. So, Mr. Harris, how would you like to proceed in terms of having an attorney?
No, I'm okay. I'm gonna represent myself. I'm a monarch or a royal sovereign. I have divine rights of a king and also sovereign rights. I have non-monetary conditions in the state of PA, personal and secure bond in Maryland, and I got surety bond here in GA. I have eminent domain, so any private property that was established like
I'd love to see him try to claim eminent domain over the jail cell toilet when some inmate needs it. Good luck making that one stick.
Solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes.
How do you want to proceed with one count of criminal trespass cited against you from December 25th, 2024?
Not guilty. I had a going on for a bus ticket back to Tampa, Florida. I only been there 2 days, and then I got arrested. I already was established and shown the paperwork of my sovereignty.
Okay, well, that is certainly not a very pleasant welcome to Georgia. So, as you are planning to enter not guilty, I am going to arraign your case. Would you like me to read the accusation, or do you waive a reading of the accusation?
I can waive it.
Okay, so Mr. Tyrone Harris in Fulton County, Georgia, you are accused of criminal trespass at the Greyhound bus station at 2324 Forsyth Street, Atlanta, Georgia, Fulton County, on December 25th, 2024. Your accusation is 24 CR 8301G. This is a misdemeanor offense. You are legally presumed innocent of the charge, and upon your entry of a not guilty plea, the case will be scheduled for trial before the division judge. At the time of the trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt. At the time of the trial, if the prosecution prevails and overcomes your legal presumption of innocence, you could be found guilty and face a possible penalty of up to a year in prison and or up to $1,000 fine. Given this information, and the division judge will be John Mather, how do you plead to this particular misdemeanor offense?
Not guilty. One of the officers said he was going to compensate me for a bus ticket beforehand, so probably on a radio record. So it was just a lot. There was a misunderstanding that was going on. Like I said before, I have divine rights of a king and also a sovereign citizen.
Well, I'm sure those rights can come in handy when you go to trial, but presently, I'm exercising your right to an arraignment. And your right to arraignment is you will have a trial. It'll be scheduled before Judge Mather. You presently have a $2,000 good bond. And if you do make bond, make sure that you give us a good mailing address so that we can send you notice of your trial date. Failure to appear for your trial date can result in a bench warrant for your arrest.
So even if I have a surety bond, which is a creditor that's guaranteed to have his debt paid by the debtor, I still can't be released before trial.
You can come up with $2,000 of legal U.S. tender, or you can go through one of our bonding companies. We have lots of them in Fulton County, Georgia. Or you can pledge equity in any real estate as long as you have legal title to that property that the sheriff's department will accept.
So even if I have, even in the Commonwealth,
the answer to that question is no. The answer to that question is no. I've already given you the three options.
So you're just going over something that you're not even supposed to be going over.
You're absolutely correct.
Okay, I appreciate that for that information and for that truthful answer you said. So.
Understood. Thank you. All right, Mr. Harris' case is been